All right, we are back. Da, 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 da. Something didn't come up right. Here it is. Here it bees. So it looks like something's up with a headphone port on my computer. I can connect wireless, but can't connect through the ports. So I have no idea what the hell is going on with that. Let me see. Let's have a little fun. Da, 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 da. Let me make a post real quick. What's up, my perps? Let's see. Let me get a couple things out of the way real fast. I'm going to get this. I wasn't screwing around trying to listen to that freaking moron of a VP we had. I could have all this already set up. I was in the process of going to get this set up when I saw she was going to be speaking on gun violence, which means she's just going to be letting words fall out of her face that really don't have a whole lot of meaning to them. And that was about it. Oh, yeah, that's who it was. So I screwed up the recording on this last night, but this was the community empowerment or empowerment advocacy to end gun violence training through the NAACP, Brady and Team Enough. Yeah, that's where I mentioned Maj Toure, and they kicked my ass out of that meeting. It's mighty nice of them. I did get the clip from it, but hey, Taco, what's up? And yeah, you ain't far from that one, bro. It is definitely the arguments where they try to fuck us. Very much badly. Like, very, very much badly. So we're going to get it rolling in just a sec. Da, 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 da. All right, I think I got that out. Oh, what was this dumb posting? Okay. A bunch of people that don't understand markets or how they're influenced or how they're controlled posting on shit. Okay. In other words, a bunch of non-playable characters who are doing nothing but puking out shit they heard on MSNBC. All right, so let's do one thing real fast. Where's it at? Let me pull something. I haven't read through all of the decision because we've got a decision in this case. Oral arguments were in 2023. We just got the decision for the case. I'm still reading through that, and I haven't got far through it yet. Because to be honest with you, it makes my fucking head hurt with the arguments these idiots can come up with. Yeah, Kamala Harris is definitely a fucking diversity hire, to say the least. No doubt. All right, let's start this off.
Ko e ko ka aha, inahe kuliana I mua o kea aha ho o kolo ki e hano o kumaku aina o Hawaii. E naoi mai, e maliu mai, I lohe ia kaleo. Hear ye, all persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh, give your attention, and you shall be heard.
Yeah, you'll be heard.
Inoho ilalo, please be seated.
Please call the case.
Case number SCAP-22-00000561, State of Hawaii versus Christopher L. Wilson. Arguing for the plaintiff-appellant, Richard B. Rost. Arguing for the defendant-appellee, Benjamin E. Lowenthal. Argument on the merits.
All right, good morning, aloha, everyone. Today's proceeding is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. I'd like to welcome our substitute justices, Judge To'oto'o and Judge Morikawa, and thank them for joining us today. Counsel, are you both ready to proceed? All right. We've allotted 30 minutes for each side. Mr. Rost, you'll have 25 minutes with 5 minutes for rebuttal, and Mr. Lowenthal, you'll have 30 minutes. Mr. Rost, please proceed.
Thank you, Mr. Chief Justice. May it please the court, Richard B. Rost for the state of Hawaii. As the court knows, we're here today because of what the United States Supreme Court did in the Bruin case. And the Bruin is a difficult case from an internal consistency standpoint, from reconciling what the concurrences say with what the majority says, and from what the lower courts have done with Bruin since it was decided just in the last month. A circuit split has developed between the Third and Eighth Circuits regarding the federal felon in possession statute. So I would like to suggest there's a way for the court to resolve this case without attempting to puzzle out the ill-defined contours of what Bruin really stands for, and that's standing. Put simply, Defendant Wilson doesn't have it. Bruin's a case about licensing requirements. It found New York's licensing statute to carry a firearm was too strict. But here, we never get to Hawaii's licensing requirements for the simple reason that Defendant Wilson never bothered to apply for a license to carry the firearm he illegally possessed. Now, the general rule is that an accused only has standing to challenge constitutionally the statute that he's charged with violating. That goes back to at least 1971 in State versus Krahovic. Here, Mr. Wilson isn't really challenging the constitutionality of the statutes he's charged with violating, the place to keep statutes, 134, 25, and 27. He's really trying to challenge 134.9, which is the licensing statute. And that's the statute he never applied under. State versus Armitage, all
right, so let's hit this real quick. Law of self-defense is doing a show too, pretty much on this very same issue, which a lot of guys are. To break it down really, really like stupid simple, this guy bought a gun outside of Hawaii, brought it back into Hawaii, because in Hawaii, he wouldn't have been able to purchase a gun until he could get a permit. At that time, I think Hawaii had only issued like 2 permits, period. And I think that was on all of the islands. And on his island, They hadn't issued a single permit because they were a may issue state where you had to jump through all these different damn hoops. And the court's going to, or the state's going to argue here, well, he never applied for the permit, so, he can't argue the permitting scheme. If your permitting scheme will not let someone get the permit, then yes, they can argue that. So he's trying to say he doesn't have standing to argue that part of this, which is absolutely fucking ridiculous. And only a bunch of leftist damn lawyers can come up with these fucking arguments. Well, them and gun control groups.
Makes the outcome here clear. State versus Armitage, the challenge was related to the Koholave entry permit system. And this court said, you didn't apply for a permit to enter Koholave. Accordingly, you have no standing to challenge the permitting process. The same applies here. Mr. Wilson never applied for a firearm carry license. And as a result, he's got no standing to complain about 134-9.
What if he could argue that applying would have been futile, that he would have been denied a permit based on aspects of the statute that have since been invalidated by Bruin? How does that affect the analysis?
Well, I think, well, first of all, the record, we don't know that based on this record. There's nothing to really show what his rationale was, and maybe he had a really good rationale to have a firearm, but we don't know that because he never applied. The other part of that analysis
He would have had to justify.
it's highly problematic because he might have been denied for a completely proper reason, and that's that, among others, he wanted to carry a gun he had no permit to acquire in the first place. So if he had applied, he might have well been denied for a completely constitutional reason, and that's another reason he shouldn't be able to raise this challenge after the fact.
I thought he challenged 134-25 and 134-27 in the second motion to dismiss the constitutionality.
He is challenging the constitutionality of place to keep, but that, in the state's view, that's really just a challenge to the licensing system.
But aren't you asking that this court set aside the dismissal of those two charges so that those charges can proceed?
Yes.
And you're arguing that he doesn't have standing to assert that?
I'm arguing that the Bruin-based challenge he's trying to bring is a challenge to 134-9.
You're saying that Bruin only stands for the proposition that of a license, of the licensing scheme.
That was the holding of Bruin, was that New York made it too hard to get a license.
But because of the requirements, right?
Right. New York imposed a proper cause requirement, and the U.S. Supreme Court said that was a violation of the Second Amendment to make that.
Well, don't we have to try to anticipate what might happen with this case if it were to go to the United States Supreme Court?
Well, I think if you rule on standing, it's probably not going to go to the U.S. Supreme Court. If you rule on the merits, then sure. I think that then, yeah, you have to try to figure out what the U.S. Supreme Court.
All right. Then perhaps you could address the merits.
Sure. If we go past standing and get to the merits, Bruin repeatedly emphasized the Second Amendment right is for self-defense for law-abiding citizens. This is not a case where the person carrying the firearm was law-abiding for several reasons. One, he didn't legally acquire the firearm. Two, he didn't try to follow the licensing regime to get a license to carry the firearm. Three, he was committing a criminal trespass, or he's alleged to have committed a criminal trespass while he was carrying the firearm. One of the cases we cited in the opening brief from California, People versus Gonzalez, says we're aware of no, this is post-Bruin, of course, we're aware of no decision holding that the United States Constitution protects the right to carry a gun while simultaneously engaging in criminal conduct, which is what Mr. Wilson is accused of here. So even if we go past standing, go past the fact that Mr. Wilson never really challenged 134-9, we're still outside the Second Amendment protections because he wasn't law-abiding. And what Bruin says over a dozen times, the right of self-defense belongs to law-abiding citizens. So on that basis, there's really no basis to find a Second Amendment violation here because Mr. Wilson's conduct wasn't protected.
Let me step back to the standing. You know, Wilson's not charged with 134.9. In fact, that's not even a crime.
Correct.
But with 134.25, 134.27, there seems to be a close relationship, if not a connection, between those regulations and what he's actually charged with, the place to keep in the ammo. So, you know, under our generally broad standing requirements, why shouldn't he have standing to challenge 134.9 when it totally relates to the 134.25 and 27 charges?
Well, it definitely relates, and I agree with you on that, but I would say that this is very analogous to Armitage, where this court said, you didn't follow the permitting process, so you don't get to challenge that process. I don't see any difference between what happened there and what's going on in this case.
I'm actually reading.
It causes a problem because
decision now, so that's why you see
what Mr. Wilson's essentially advocating for here is, well, if one requirement of the licensing regime is invalid, the entire thing must be thrown out. I don't have to comply with any aspect of it, including the aspects
What's
which
up,
are
Dangle Matt?
unquestionably constitutional under
What's
Bruin.
happening, my brother?
For example, showing you're not a felon, showing you're not mentally ill or mentally deranged, as the statute puts it. Those are requirements under the licensing regime that are clearly constitutional.
Well, let me ask you this. Is it clearly constitutional? Is it consistent with
what's up, my brother?
our nation's historic traditions of firearms regulations that mentally ill people cannot have firearms?
Well, according to Justice Kavanaugh, it is in his concurrence joined by Chief Justice Roberts, and given the three dissenters from Bruin, I think that position would hold a majority of the U.S. Supreme Court.
Did he cite any particular law, history, and tradition of precluding mentally ill people who are acquitted of crimes?
Not as such, and I mean that's part of the reason Bruin is difficult to deal with. The majority opinion says, well, shall issue licensing regimes where you just ask for a license and you get it. Those are constitutional, those are fine, et cetera, but at no point does it try to explain what the historical tradition is that allows a shall issue licensing regime versus a may issue licensing regime. So Bruin is, as I said, difficult to deal with, and all we can go with is what the court has said. I mean, Bruin doesn't overrule Heller and McDonald, which are cases that say there are legitimate restrictions.
But, you know, it seems that what they did.
Now there is a couple things screwy about this case. Let's kind of touch on that a little bit. One, this guy was arrested for trespassing in a fenced area. I don't know how he got there. I don't know what he was doing while he was there. Him and he's with a couple other guys. I don't know where they got lost, whether they were just goofing off, whether they didn't realize where they were at. But the owner of the property came out with his AR-15, held these guys at gunpoint until the police got there. A defensive gun use, by the way. And the guy, I guess, did have his permit and all this shit for his AR. But when they go to arrest this guy, he tells them, hey, I've got this 22 pistol, 10 rounds on me. And that was his arrest. And again, that part of it, I don't think has went to court yet. So there's been no explanation why he was there. From what I understand, he doesn't have any kind of criminal history, nothing like that. So it's not like he was, the gangster out there trying to do shit. And part of what the state's arguing here is, well, since he was involved in this trespass, well, none of these arguments count anyway because it was a criminal act. That part hasn't been through the justice system yet. As far as, the end result of the case. So as far as I know, he hadn't been convicted of all that. But even with a trespass or something like that, unless you can prove he had criminal intent to do something, that doesn't negate his arguments with, hey, I couldn't get a permit. Nobody was getting permits. They made it impossible to get permits. So yes, I was carrying a gun for self-defense. I haven't heard about it in him pointing the gun at anybody. Nothing came up about the gun till he was arrested. He told the cops that he had it. So this doesn't seem like a violent person trying to go out and do violent things. That's part of where this trespass charge kind of confuses me a little bit. But still, that doesn't negate the guy's arguments, and the state's trying to play fuck games as usual. There's a couple parts of this opinion when I hit a couple places. Maybe we'll read them real quick that are, well, absolutely insane. So let's go back through. Let's crank this back up.
Justice Thomas did with Bruin was scrap the 2008-2010 Heller McDonald. After that, courts, went back to the levels of scrutiny, balanced public safety, and used traditionally what's been going on since beginning of time on how to evaluate these regulations, and said, and basically almost airtighted things to say that, it's got to be consistent with our historical tradition.
No, it had to be consistent with the historical tradition of the United States, is what it said. Not with your traditions inside of your state, because you've been doing unconstitutional shit since before you signed on to become part of the United States. And by the way, jackass, from what I understand, your protection for arms in your Constitution is an exact copy of what it is in the federal Constitution. So the only way you argue this case, the way these guys are arguing it is if you just say, fuck that whole statute or amendment, and they just don't care. In which case, these judges ought to be removed from the court, and anybody, if they send anybody to prison or let anybody sit in prison over charges for simply having a gun, these judges ought to goddamn go to prison. That's my humble, maybe not so humble opinion, but that's my opinion.
Firearm regulations. Now, I look back at some of those historic, traditional firearms regulations. They include things like loyalty oaths, storing powder in certain places. That's where we get the term
that's why this
powder
is
from.
With Biden.
Passing muster.
There's
That
they're
term
laying the
came
groundwork
from,
to get rid of
hey,
the
let's
right
bring
wing
our muskets to the
and
town
keep
square
them
and we
first.
inspect them. Can we, Hawaii, or any state for that matter, pass a law that says, hey, we're going to go back to muster. We're going to have you show up in Kapiolani Park every year for a muster inspection. That's a historically rooted and traditional law. Would that be constitutional?
That's a good question. I think if you can, the test they've created is this, you have to find this historical and analogous provision, not a historical twin, but something analogous. So if
Let's say it's exactly analysis. Hey, we had this law back in 1791 or 1868 and says you show up, we got to inspect your firearms, make sure they're good.
Right. I think there'd be a perfectly legitimate argument that a law like that would be enforceable, especially if you could find similar laws in other states, because they do this nationwide.
So that law would be enforceable.
Oh, here's another handy dandy thing, and I think the state's going to argue this in a minute, that to be protected under the Second Amendment, the person has to be a law-abiding person. There's two things they're going to argue here. One is the trespass. We still haven't figured out what the hell was even up with the trespass. But the other one is they'll argue that since he didn't get a permit to carry, that makes him breaking a law, which makes him carrying the gun not protected by the Second Amendment. It's this circle and jerk of lawyer speak. Yep. Too many choices. Yeah.
But the fact that you pass a law that domestic violence, people have been convicted of a misdemeanor or people have a protective order against them might not be. Now, that question might be addressed with the Rahimi case that they just took cert on. But anyway, I think you understand my point, and probably that ties in with your idea about Bruin being somewhat internally inconsistent.
That is what I meant when I said that. Yes. If we're trying to apply Bruin in the historical context that they've given us, the issue is that the founders were dealing with single shot muskets, not AR-15s. There wasn't a school shooting in this country until the mid 1850s. So the problems they were addressing were not the problems we face today.
By the way, were handguns, just the elite have handguns?
Well, handguns were essentially non-existent, at least in their current form. So
Okay, so here's
trying
something
to
interesting. Let me show this. Pull this up because this gets to the trespassing. One, the court says right up here, that Wilson's criminal trespass charge is not before the court, so they're not even considering the trespass charge. And as far as how Wilson ended up in the situation, Wilson denies trespassing. Said he and his friends were hiking at night to look at the moon, native plants. Did not see any no trespass signs. Purpose of this motion to dismiss Wilson's criminal conduct does not prevent him from challenging the charges under the Second Amendment article. So they're saying right there that his trespass charge, even though the state brings it up, his trespass charge isn't even being considered in their arguments here. So their only real arguments that the state has here is since he didn't get the permit, then his actions aren't covered under the Second Amendment, even though they made it impossible to get the permit. There had never been a permit issued on his fucking island. So nobody could do it. Not carry on your person for self-defense. These fucking people are such sacks of shit. I swear to God. Yeah, and that's another good point, Chamber. And these inspections that he's talking about, these were inspections to make sure everything was in working order, making sure your powder was dried, making sure your weapons were in good condition. It wasn't, oh, you guys can't have these. You got to bring them in to be inspected so we can take them. That's all I can say right now.
apply this.
Well, Vice President Burr and Alexander Hamilton sort of, they had guns, but and that was a traditional rule, no duels. But I guess the point I was making was, as you sort of pointing out, is muskets were the thing back then, and we could get into the well-regulated militia. Maybe I'll get in with that with Mr. Lowenthal. But handguns, as far as I see, and I think the Supreme Court wants us all to be historians now, were really not in use much. And here, the Supreme Court with Bruin is saying, handguns are okay in the public, walk around the neighborhoods for self-defense purposes. Do you have any position on the fact that really handguns were not really a thing back then?
Well, I think it's difficult to apply Bruin to technologies which were non-existent. I mean, if we take Bruin to the extreme, you could say, well, there were no laws against pointing sticks in 1791, so accordingly, the government's powerless to stop me from buying a cruise missile today. There's no relationship technologically between the single-shot musket that Aaron Burr was using and a 15-shot semi-automatic handgun that you can use to commit some sort of atrocity in seconds. So I don't think that and that's why I've urged the court to think about resolving this on standing so that those questions don't have to be answered.
Mr. Rust, I would like to talk about standing a little more on coming back to your analogy to Armitage. I'm looking at the statutes that were charged, 134.25 and 134.27. They don't even refer to the permitting statute, and there's a reference except as otherwise provided in 134.9. So I'm trying to understand if your analogies actually fit a fitting one in this purpose. Is the existence of a permit an element of these offenses? I'm guessing not, because you didn't allege it. So how is it a defense? And if so, how does that all play out in terms of whether Mr. Wilson is out of luck because he didn't apply for a permit?
Well, it's an exception to 134, 25 and 27. And that's part of the issue actually the state has of what the circuit court did here. The circuit court said there's no exceptions to 134, 25 and 27.
And we'll have to read through it.
That's not true. You know, part of the problem was
another
the
case,
way
man.
Mr.
Republicans
Wilson
can
argued this
screw us
case was to
as bad as
pretend
Democrats.
134 did not exist. He didn't challenge 134.9. He didn't say 134.9 was unconstitutional under Bruin. He just argued there are no self-defense
bad.
exceptions to 134, 25 and 27, and that's not true. That 134.9 is clearly a self-defense exception. Whether it passes muster under Bruin's another question, but it is an exception.
And I just read it in
and the circuit court is just wrong when it says there are no exceptions.
Right to own bear arms is the exact same.
This ties into the argument that the state's made about self-help. This court in State versus Lobadan, following what the California Court of Appeals did in People versus Hardy in the firearms context, condemned self-help. It said, well, you're challenging your criminal conviction. You don't get to just go get a gun while that's going on and say, my conviction is going to be overturned. It's fine. I can get a gun. No, the self-help in the firearms context is simply too dangerous. You've got to comply with the licensing provisions. Mr. Wilson had to go through the process and do what the plaintiffs in Bruin did. If you're denied, file a lawsuit, challenge it in court. Don't just take your illegally obtained firearm and carry it with you while you're committing another crime.
Let me ask you this though, because you brought up, you know, the law abidingness. I mean, isn't that a trial issue? I mean, whether he trespassed, whether he was really law abiding or not, why shouldn't that be a trial issue?
Right. That's one of our other arguments is that this is the factual findings the circuit court made here invade the province of the trier of fact. You know, the finding that he was acting for self-defense, there's nothing in the record to support that. And that's a jury question. That's a question that has to be resolved by the trier of fact, what his mens rea was, what he did. So yeah, if he was law abiding, if he was engaging in self-defense, those are questions you have to resolve at a trial, not a motion to dismiss.
Are you aware, I know there are other jurisdictions who, I guess in what, you know, might be argued are analogous circumstances have held that someone who's charged with illegally possessing a weapon who didn't seek a permit lacks standing. And I realize our standing law is different from that of other states, but are you aware of any states which have gone the other way or federal courts which have gone the other way and said someone can challenge a criminal conviction, the part of the predicate of which, or at least a defense or an exception to which is having a permit, even though they didn't apply for the permit? Is there any authority out there that goes the other way?
I believe there is. Just yesterday, I saw a California Court of Appeals decision that came out a few days ago saying there was standing in slightly different circumstances, although ultimately
because they're using that to create a de facto
challenge failed for other reasons. So yeah, there's definitely been the other results. I would suggest the New York authorities we cited in the brief are very compelling, especially in light of the fact that it was New York's law that was struck down in Bruin, and the New York court still said, no, you don't get standing unless you apply for a license to carry.
Does it matter that we generally have a fairly sweeping view of standing, including in the criminal context? And
well, it could, although I think based on Armitage, based on Grahovic,
courts do this shit all the time.
You still have to apply in order to get standing. And again,
they can just blow someone.
You need to, as an example,
there's no way it should be that hard.
When I walked in here this morning, I walked by a very prominent sign,
whether or not
no
the
guns
state
allowed.
is trying to deprive people of
Should someone who has a problem with that law and that rule just say, well, Bruins probably will allow me to carry a gun into the Hawaii Supreme Court, so I'll do that? No, you should challenge that law. You should file a proper lawsuit, not just ignore it, because if you ignore the firearms regulations, the odds of violence when you encounter the police are high. And I don't think that approach should be endorsed by this court.
You mentioned, New York's framework, and Bruin did label Hawaii as a may issue jurisdiction, much like the New York law that was struck down. But does Hawaii's firearms regulation framework differ at all from New York?
It does. I mean, our statute talks about exceptional circumstances where you have some compelling need for self-defense to have this weapon, which I think is Whether it's substantively different than New York's proper cause, I'm not sure how New York has applied that proper cause standard over the years, but I think Hawaii is somewhat similar in the cause or justification requirement. That said, Hawaii does have a lot of requirements which clearly withstand Bruin. So that's another reason he should
And
apply.
Hawaii's law has not been struck down. Now, it's been amended recently, but the law that Mr. Wilson's challenging has not been struck down by any court.
Well, and when Mr. Wilson engaged in this conduct, Bruin hadn't been decided. There was really no question at the time that Hawaii's law was valid. So again, there was no reason for him not to apply when he was.
And the United States District Court here has not ruled on the Young case. Do you know what the status of that is?
It was still pending before the Ninth Circuit the last I checked on that one. So,
I thought they remanded it to the district. Is it back
yeah,
up to the
right.
Ninth
I believe they remanded it, and I don't think the district court has taken action on it as of yet.
Listen to this for a second, because we talked about how Hawaii's protection for arms, I mean, just about exactly matches the federal. They kind of run through this up here. They said it's only separated. It's like a capital letter change and a comma change or something. So it's basically the same exact thing. Then they get in here, well, textual approach to a constitutional interpretation appreciates that words appear or do not appear for a reason. Both clauses, Article 1 and Article 1, Section 17 and the Second Amendment use military-tinged language, well-regulated militia, and bear arms to limit the use of deadly weapons to a military purpose. There are no words that mention a personal right to possess lethal weapons in public places for possible self-defense. Why does it even mention then that it is the right of the people to keep and bear arms? Why wouldn't they say, because these were pretty sharp people, why wouldn't it say it's the right of the people in the militia to possess arms, or the right of the militia to keep and bear arms, and if you're not part of the militia you can't keep these arms? These were people smart enough to come up with our constitutional system, apparently not smart enough to make it bulletproof. But you're telling me they were so simple-minded they couldn't write an exception to people being able to use arms or not use arms, or to say that the people can't own arms? You're telling me these motherfuckers couldn't have written that if that was their intent? Even though if you look at their letters, whether it's Benjamin Franklin, whether it's Tench Cox, whatever, all of them talking about the people owning arms and that every man should go armed, be trained in arms. All of their letters. Tench talked about every implement of the soldier, no matter how terrible, was the birthright of every American. You're telling me these motherfuckers didn't plan on private citizens owning arms? If that is your argument, you're a fucking idiot. Sorry about the language sometimes, guys, but damn. These people are mind-numbingly, absolutely moronic.
Sorry.
Why shouldn't the declaration that he,
Barnaby,
through Mr.
what's up,
Lowenthal,
my
his
brother?
client,
Yeah, you're right.
it's a declaration per HRPP 47A. Why shouldn't the fact that Mr. Lowenthal represented his client had the firearm for self-defense? Isn't that just like your representations about Florida?
At some level, there's a similarity there. I will agree with you that those are just representations, but there's two reasons why. I mean, Mr. Lowenthal's declaration doesn't say my client tells me that it was for self-defense or something like that. It just says, well, everything in this motion is based on something in the record, or something in discovery, but I'm not going to tell you what it is, essentially. So none of that was put before the court. So I don't see how you can just say, well, okay, he says this, so we're going to accept it. Moreover, the cases we cited in the brief hold that, state of mind, that's a question for the trier of fact. It's not something the circuit court should be deciding on a motion to dismiss, especially not, a declaration from the defense attorney, a declaration from the prosecutor. I'm going to make a finding on why Mr. Wilson was carrying this weapon. That can't be the proper way to do that, especially when you're declaring a statute unconstitutional, which, as the court knows, is you've got to show beyond a reasonable doubt the statute's unconstitutional. So this record doesn't support that finding at all. And more to the point that the finding that Mr. Wilson was engaging in self-defense when he was carrying this weapon isn't harmless. It's not harmless to the state because, again, Bruin ties the Second Amendment right to engaging in self-defense. So when the circuit court found that, it's essentially saying, well, you fall under Bruin. But again, we don't know what he was doing.
But isn't it, any defendant who is charged with a firearms defense, isn't it just easy? Aren't they all going to just say, hey, I had it for self-defense, and I had my gun for self-defense? It doesn't seem like that's such a hard barrier to show.
Well, they can certainly say that, but
I'm walking around the neighborhood. I'm going to non-sensitive places. Why am I doing it? It's for self-defense. What other reason? It seems that just is an obvious. It's a nothing burger. It seems everybody's gonna say it's for self-defense.
Well, sure, I agree. Most people will probably say that. I think the court can look at the circumstances and question whether that's accurate, because in this case, he took his firearm when he went off to trespass on someone's property. Who's he planning to defend himself from? The rightful property owner, the police, if they show up? Those are questions you have to resolve at a trial, not just allowing Mr. Wilson to say, well, it was self-defense, so I fall under Bruin and the state's powerless to stop me from doing anything. Part of that too is, as you indicated, Justice, Hawaii's got a new statute coming in January 1st, so a new version of 134-9. I don't think going forward the court wants to tell anyone who disagrees with the new version of 134-9.
Can you give us that act number?
It's 1230, maybe.
1230.
I don't have the act number, I'm sorry. Or maybe I do.
While they figure that out, let's read something else real fast that's kind of interesting. And I've heard this argument, or seen this argument used in the last little bit, that the Second Amendment didn't apply to all people at the time. It was only, white men, landowners, a lot of that could own arms. So if it didn't apply to everyone then, it can't apply to everyone now. Okay, take that same logic, you bunch of douchebags, and apply that to every other right that you claim is a constitutional right, whether it's voting, whether it's speech. Just name another right that you're fucking drilling down like that and trying to keep in that little ass box. So centuries ago, the right to keep and bear arms was not universal. It wasn't for all. The people who had the right to keep and bear arms included a discrete subset, one that excluded people based on gender and race. Only able-bodied free men could join a militia. Oh, you fucking people make my head hurt. That doesn't mean the right wasn't for the people. It means they had a smaller definition of who the people were at the time. That definition of people has been expanded. The right stays the same. It is still the right for the people. Just because they were shitty back then at including everybody doesn't mean that the right itself is somehow not a right. Like it means less. If we switch this to, took out the Second Amendment, if we switch this to our right to free speech, people would lose their ever-loving fucking minds over it. But since it's the Second Amendment and it's a right to bear arms, oh, well, that's okay. We can exclude all this and we don't have to follow it. I'm telling you, man, they're intellectually dishonest people. Or they're just lying
I
straight
find
to
it
the face.
instantly, I'm sorry. But when that statute takes effect on January 1st, I think it would be very dangerous for public safety if the ruling is, well, if you disagree with the new version of 134-9, go ahead, get a firearm, carry it around. Do not bother to try to comply with the new
134.9 was when they were
because if you're able to succeed on a Bruin challenge to 134.9,
May issue,
you'll get off scot-free. I don't think the court wants to send that message that these the licensing requirements are just sort of up for debate and you can ignore them and have an
they're not up for debate. They're absolute bullshit.
Challenge where you say, well, that Bruin allowed my conduct, so I even though I carried a gun without a license, which is precisely what's prohibited by place to keep, I can't be punished for that. I see my time is up, so I'll save my time for rebuttal unless there are any questions.
Okay, thank you, Mr. Rost. We'll hear from Mr. Lowenthal.
Yeah, that too. My JSD hat on.
Good morning. May it please the court. The issue before this court is a narrow one. Does a person have standing to challenge the constitutionality of the criminal statute they are accused of violating? And the answer from this court for the last 50 years has been yes. Standing requirements in Hawaii, both in criminal and civil, are born out of this idea that standing cannot and must not be a barrier for cases and controversies, for issues to justice.
But these justices use,
and that is exactly the position by the state here, which is the only way to challenge the statute would be through a civil declaratory judgment, presumably, and that criminal defendants are unable to raise a constitutional challenge as they face the prospect of being convicted and sentenced to prison. It is a way of shutting off judicial review. And the state cannot shield its prosecutions from judicial review of constitutional challenges of these statutes. Now, the state has, in its briefs, played up fears of violence and chaos of what would happen, and maintains today that if this court rules that there's no standing, everything is going to be fine and everything's going to go away. We would submit that that's simply not the case. A ruling of standing that would prevent people from challenging the constitutionality of place to keep wouldn't stop more challenges. It would create, we are dealing with a federal constitutional right, arguably a state constitutional right as well. And it wouldn't prevent litigants from seeking redress in the federal courts should there be a higher standing burden that would prevent courts from even having the ability to review a constitutional challenge in an individual case. So the question of standing should be application of the general rule. Mr. Wilson has been accused of violating 134.25, 134.27. He, like any other criminal defendant, has an ability to challenge those statutes as they apply in this case.
And those are the only two statutes you are challenging at this point, is that right?
That is correct. Mr. Wilson's not in a position to challenge 134.9 because this isn't a civil case in which they're bringing a challenge to the licensing restriction. And I part ways with my colleague in the state about Bruin being read so narrowly that we're only dealing with license restrictions. It goes beyond that. And Bruin gives us a standard to approach all regulations, all statutes in the context of the Second Amendment.
What about Mr. Rost's argument that the Armitage case is very similar and provides an instructive analogy for finding no standing here?
If you argue
know,
shit like this with people from the founding era, they laugh at your.
We cite
fucking-
Armitage as well. And so it's never a good position when both sides are saying, based on the same case. But if Armitage trods out the general rule in criminal cases, in Armitage, they actually wanted to challenge two regulations. And without getting tripped up over my words, one ends in a 10, one ends in 11. I believe Mr. Armitage was charged with violating the regulation number 10. And so what this court did was said, Mr. Armitage doesn't have standing for number 11 because he never availed himself to the permitting process. We're only going to limit our constitutional focus to the regulation he's actually charged with violating, which is 10. And so that is an application of the general rule of standing. And it does fit nicely with the situation here.
Well, you know, Mr. Ross also cited Gravac. That's from 1971. And what that states, standing challenge only specific penal sections with which charge. And then Armitage has, you know, was riffing off of that. And Armitage has this language: a criminal defendant cannot challenge the constitutionality of one section of a statute where charged under a different subsection. So that language seems to support Mr. Rost's position. How does it not?
It supports it to the extent that there's a challenge to 134.9, but this isn't a challenge to 134.9. I direct the actual language in 134.25 for handguns is in subsection B. It is unlawful to possess and carry in violation of 134.25A. So, I mean, the language that is being challenged is in the statutes in which Mr. Wilson is charged with.
The statutes also reference 134.9, which is the question I asked him. Is it, I guess it's not an element. It wasn't charged as an element of the offense, but is it an affirmative defense? Is it something else? And if so, is it fair to say that by not challenging it, he's given up the ability to proceed with saying that it was challenging this to the charge that he was accused of?
I'm very glad that you've brought up this issue as to whether that is an element or a defense. I would submit that it is an element. If we were to look at the older iteration of place to keep, and we look at our standard jury instructions, they identify it as an element. And the fact that it wasn't pleaded is an issue for another day. But to say that it's neither an element or a defense, it's just this thing that needs to be done in order to raise a constitutional challenge puts us in an extremely unclear and hazy place. I will say that at the end of the day, I do believe Armitage is unclear because the regulations do reference each other. On one hand, it says there is standing to challenge the regulation in which Mr. Armitage is charged with. On the other hand, we can't go the whole hog and talk about this licensing scheme because he never availed himself to it. I would submit, though, that carrying or possessing a firearm without getting the permit under 134.5, the hunting permit, or 134.9, a carry permit, is an element that needs to be established by the state at a trial. That really isn't getting to the issue of Bruin, though, because if we look at Bruin, Bruin talks about conduct, not about attendant circumstances. Is the conduct at issue covered by the Second Amendment? That's the first part of this Bruin prong. And the conduct, when we look at place to keep, is possessing and carrying. That's what was asserted below. There was no pushback from the other side. There was no opposition to that on the other side. This is actually the first time the state is getting into the merits of the Bruin standard itself. This today. They never raised it below. They never raised it in their briefs. And so it was asserted in front of the trial court that conduct, carrying the firearm for self-defense purposes, is covered by the Second Amendment. Once that happens, it's presumed to be constitutionally protected conduct, and the burden shifts to the state to justify the regulation.
How do you respond to Mr. Ross' argument that it was improper for the trial judge to find self-defense.
The position of the defense is like any other constitutional rights, they should be raised in a motion to dismiss. I would respectfully disagree that the trier of fact, a jury, would determine whether this prosecution is constitutional or not. That is something to be addressed by a trial court pre-trial, just like with, say, Native Hawaiian rights in the Hanapi case, in the Pratt case, those were all motions to dismiss. Motions to dismiss under First Amendment grounds, those are always brought pre-trial. These are not issues that are raised or should be raised to a jury. We would object to that or disagree with that. The state has waived the evidentiary challenge to the facts below. They have raised it for the first time here on appeal. They had every opportunity. They had every opportunity in their memo in opposition at the hearing. They didn't really raise it in a motion for reconsideration, and it's only now on appeal for the first time that they are raising it. And it's our position that that issue has been waived, and they are with the record they have before them. And so for this court, in resolving what we have here, our position is asking to affirm the dismissal of counts 1 and 2. This court has the ability to affirm it simply by saying, yes, criminal defendants have standing to challenge place to keep to
Trying to
raise a
harass
Second
Jim
Amendment
Jordan
issue.
right now.
And once that happens, it should be played out in the trial courts to apply Bruin for the particulars of each and every case. To say that they don't have standing would essentially be shutting off judicial review for all of these cases, which would be unprecedented, which would be different than anything this court has ever done before.
How do you respond to Mr. Ross' position that, New York, maybe California have decided quite similar situations where the defendants, didn't bother to apply for a carry license? I mean, People versus Rodriguez seems kind of exactly on what we're dealing with here.
My response is
Gabriel, what's up, my brother?
California, New York, they got out there pretty quickly after Bruin. And it looks like with these motions, so it looks like Hawaii will be doing the same.
Hey, McCrice, what's happening,
Since
brother?
that
man?
time, we've seen Bruin applied to many different types of regulations, especially in the federal courts. And we have our own body of law with standing that is pretty well established, going back to Gramavoc in the early 1970s, and also in the context.
Let's look at one thing or another thing real fast. Actually, two. Let me move back over here because this is in the decision in the case. They're getting into the corpus linguistics, talking about the language. Found in error sources almost always use bearing arms as an unambiguously military sense. And they go through here, non-military uses of bearing arms in reference to hunting or personal self-defense are not just rare, but they are almost non-existent. So they're claiming the Second Amendment, whether it's Hawaii's Constitution or the Constitution of the United States, just have a military sense to them. Now, let me share this. So this is from Buckeye Firearms Association, but I have looked at these. You can find all these quotes in the papers they were in. You can go right to the Library of Congress and find them and read them in their original context. I'm not going to put you guys through that pain. However, if we're talking about the Second Amendment and you try to tell me that the Second Amendment is just there for people in a militia, it is not a personal right. I believe that these people would disagree with you, considering here is one quote: a free people not only be armed, but disciplined. A free man shall never be debarred from the use of arms. I prefer dangerous freedom over peaceful slavery. What country can preserve its liberties if their rulers are not warned from time to time that the people preserve the spirit of resistance? Let them take up arms. Let's see. The laws that forbid the carrying of arms are laws. Laws that are, I'm going to learn to read one day. The laws that forbid the carrying of arms are laws of such nature. They disarm only those who are neither inclined nor determined to commit crimes. Such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage rather than to prevent homicides. For an unarmed man may be attacked with greater confidence than an armed man. Good old Thomas Jefferson. Ooh. Wrote a lot of good shit, did a lot of dumb shit. But in all of these are explaining the Second Amendment, what the purpose was for the Second Amendment. These are letters going back and forth. This one's kind of a long one. A strong body makes the mind strong. As to the species of exercise, I advise the gun. While this gives moderate exercise to the body, it gives boldness, expertise, and independence to the mind. Games played with the ball and others of that nature are too violent for the body and stamp no character on the mind. Let your gun, therefore, be your constant companion of your walks. But this little handy-dandy bit. The Constitution of most of our states, talking about the original states, assert that all power is inherent in the people, that they may exercise it by themselves. That is their right and duty to be armed at all times. Yeah, it really sounds like they're talking about a fucking militia, doesn't it? Seems like that's a little bit of an independent personal right that they're talking about. And we'll look at some of these as we go. But do any of those quotes, any of them, seem like they point to this only if you're in the militia kind of right? No, and we'll look at more of them later, but none of that is pointing to a militia. It is pointing to individual rights. Why? And the only reason that you can argue the shit like they're arguing it is if you are such a fucking intellectually dishonest or lazy son of a bitch that you can't do the very basic fucking research to find out what the founders said about these individual rights.
Civil law, our standing requirements in Hawaii aren't restrictive. They're meant so that these issues can be played out in court.
But, I think his point, Mr. Rouse's point, and the prosecution's point is just, it's not really we're precluding you from standing. If you had applied,
what's up, my
or at least
brother?
tried, you would have standing to challenge 134, 25, and 27.
I believe the position from the state is the only way to challenge it is by
YouTube won't
going
let you comment.
through a civil action and trying to apply for a permit, being denied, and then suing whoever needs to be sued to raise the issue. That's what they appear to be saying. Now, there is another class of criminal defendants that I guess in theory would have applied, denied, and went out anyway,
Sons of bitches.
and was later prosecuted for place to keep.
Tench is one of the best ones.
But it does not, that distinction does not appear to be anywhere in the state's position.
I didn't understand your last point.
I guess there is another class of criminal defendants that could say, I applied, I was denied, and I went out anyway with a firearm, and now I'm being prosecuted with place to keep.
I see.
But
As opposed to filing a civil action. You
Correct.
could have applied for the permit denied. Respectfully, I disagree with the denial, and I'm going to assert my right to carry my weapon. And if I'm arrested, then I would challenge.
precisely.
Very much
And-
disrespectfully
but I would say that
or disagree.
that narrow class of criminal defendants is a very, very cabined ruling of our standing rules.
Well, but that would have been Mr. Wilson's situation if he had, registered the firearm and applied for it. That would have been his precise situation. Then he's on Mr. Ting's property. And it seems like that's the difference in that That would be a clear-cut standing versus the situation like Rodriguez or here, where there was just an absence of an attempt to get a license.
Right. And these facts do play out differently with every type of prosecution. You have here a person who is walking on a trail that's cutting up into the West Maui Mountains, is later brought back to the road, informs the police that he has a firearm, never brandishes the firearm, never points it at anybody. That person's being prosecuted with place to keep. It's our position, Mr. Wilson has every right and to, at the very least, raise the issue as to whether this is a constitutional application of place to keep. In contrast to, say, another place to keep prosecution where there are persons in a residential neighborhood with a sawed-off shotgun or something like that. That person, we would submit, also has standing. But again, once we get to the Bruin application, whether that conduct is protected, that's where this application of the merits of Bruin comes into play in various types of
I can't
motions
get
to
through a
dismiss.
couple pages in this damn
I want to step
decision without wanting
really
to
far
use
back
it.
to 1938 or 1939.
Yeah,
To the
I
United
mentioned
States
that one
versus
earlier, Gabriel.
Miller.
Yeah. Every
This
implement
was
of
the
the
last
soldier, no
word
matter
on the
how
Second Amendment
terrible,
before Heller
listed a couple things, was the
by the US
birthright of
Supreme
every
Court.
American.
Or all hell or broke loose?
Yeah.
Birthright of American.
Yes. Before, yes.
I may have that quote.
And in Miller, it's a criminal case. It's two Oklahoma bank robbers with a sawed-off shotgun getting prosecuted for having a sawed-off shotgun. And they argued they have a Second Amendment right to have a sawed-off shotgun, maybe as they're robbing a bank, as crazy as that sounds, but that's what they argue in 1938, 1939. And the US Supreme Court did not get hung up on standing. They went straight to the merits. They addressed the claim. That's exactly what Mr. Wilson is doing, the exact same thing. Now we're on the other side of Heller. It's a criminal case. He's being prosecuted.
Was that a place to keep case, or was it a prohibition on carrying a particular type of weapon that could not have
I'm gonna find.
plausibly been licensed? Although I guess he could have applied to the Bureau of Alcohol, Tobacco, and Firearms for a sawed-off shotgun permit. Not very often granted.
I did not
Yes,
prepare
they
what
are,
agency
jackass.
to
They
apply
give
for
SBR
in
permits all the
Prohibition
time.
era Oklahoma, but perhaps. I guess I raised the case, or I cite the case to show that they did not get hung up on standing in a criminal case. Then the United States Supreme Court addressed the constitutionality of their claim. This court did it in Mendoza as well, back in the 1990s. So to say that this can all be resolved with standing, we would disagree with that. Standing cannot prevent or be a form of almost like wishful thinking to say that these constitutional challenges will just go away by saying none of these people have standing and they can.
What's your position, or what's the defense position on the circuit court's apparent holding that the state constitution provided similar rights to the federal constitution?
So the state constitution has a provision that mirrors the Second Amendment. And the last word from this court was, it was unclear whether this court held that the state constitution called it a collective right or an individual one.
All right, and that's what we're going to talk about here. So let's see. Let's share this tab instead. And there were a couple quotes from Tench on here. And I'm going to try to find some of the other ones real quick. Now, Tench does mention stuff about the militia, but he also talks about the individual. As civil rulers not having their duty to the people before them may attempt to tyrannize as the military forces, which must be occasionally raised to defend the country, might prevent their power to the injury of their fellow citizens. So might pervert their power to the injury of their fellow citizens. In other words, misusing the army against the citizens. The people are confirmed by the article in their right to keep and bear their private arms. Then he says, who are the militia? Are they not ourselves? It is feared then that we shall turn our arms, each man against his own. Congress may have no power to disarm the militia, their swords, and every other terrible implement of the soldier are the birthright of Americans. So he does mention the militia here, but he's talking about the birthright of an American, period. So yeah, he does talk about some about the militia, but he's also talking about individual rights. It's not that fucking hard unless you're just an idiot who just rejects reality just to insert your own fucking opinion. AG, yeah, dude, you ain't wrong. The same Democrats that have been for gun control forever, and some Republicans, a lot of this does have to do with race. When Reagan signed in a bunch of shit, it was definitely about race. Couldn't let the Black Panthers be armed to patrol their streets and keep cops from actually just, abusing people, which was a lot of what they were doing. What can I fucking say? It makes my head hurt. All right. Let's see. There was another quote I wanted to look at real fast. Where was it at? Well, there's actually a bunch of them, but and this one really got down to the heart of it. Yeah. Well, here's another good one. This was William Pitt. Necessity is a plea for every infringement of human freedom, the argument of tyrants. It is the creed of slaves. It's for the children. We have to do this. No, you don't, motherfucker. Leave my shit alone. Oh, here's another good one for individual rights. Besides the advantage of being armed, which the Americans possess over the people of almost every other nation. See, they're talking about the people, the existence of subordinate governments to which the people are attached, and by which the militia officers are appointed, forms a barrier against enterprises of ambition more insurmountable than any which a simple government of any form can admit of. But see, he's talking about over the people of any other country. So he's talking about the Americans, and the difference in our rights over the people of almost any other nation. It's talking about the people. They didn't say militias and shit again. He mentions militia, but this is still an individual right. Who the fuck do you think makes a militia up? Oh, that's right, individuals. I ask, who are their militia? They consist now of the whole people except a few public officers. The whole people. That's your average American. And then this quote right here from Mason: to disarm the people is the most effectual way to enslave them. You think? So yeah, when these people are talking about, oh, this is a collective right, not an individual right, they are being.
I believe it was Justice Levinson who wrote it in Mendoza that said, and even if it was collective or not, we're going to apply rational basis. And so a lot has happened since then in federal courts with the Second Amendment. And it is our position that at the very least, if there is an approach, my suggestion would be, if conduct is not covered by the Second Amendment, that is the first prong of Bruin, then we look at Mendoza, and then we can see whatever test would be available. This is not the first time the court had done something like that when the court was struggling with Crawford.
Well, why would we look at Mendoza when they basically opt to answer the question on whether it was a collective or individual right?
Under the Second Amendment, that's been incorporated. I would give you that.
I mean, the only difference is 2 commas and 2 capitalizations. And look, all the way throughout our history to 2008, every court that looked at this decided that the Second Amendment was a collective right, not an individual right. And from what I understand, 45 of our states have enshrined the individual right and all but 5 of those 45 plucked the well-regulated militia language out of it. So does that suggest to you that these states did that because the Second Amendment, known up until 2008, was a collective right, not an individual right?
Thank you. I dare not second guess Justice Scalia in writing Heller. All I can say
I would second guess the shit out of
is
him.
up until Heller, there was a theory that it was an individual right. And it was a theory that had been endorsed
Heller people
wholeheartedly
praised all
by
the
the
time.
United
Heller
States
was a
Supreme Court
very
in Heller.
shitty decision.
Wouldn't that theory have been well known to the
Written very poorly.
framers of our constitutional provision at the time that our provision was adopted? And would that lend support to the thought that our framers intended it to be a collective right
It is
for our voters?
It is entirely possible that our state provision is a collective right still. Without getting into the details as to whether our Constitution also adopts the national Constitution or not, the language of the Hawaii constitutional provision does allow this court to maintain that the state constitutional right is a collective one. But where does that leave us? And my suggestion is we still have to deal with Bruin. We still have to deal with an incorporated Second Amendment. And we still have to deal with an individual right.
Again, let's get back to this because this is another good one because we're talking about whether this was an individual right or a collective right. All of these letters are pretty much written in explaining the Second Amendment, and there were different questions being asked. So sometimes they mention the militia, sometimes they don't. So, Noah Webster. Before a standing army can rule, the people must be disarmed. Who must be disarmed? The people must be disarmed. As they are in almost every country in Europe. The supreme power in America cannot enforce unjust laws by the sword because the whole body of the people are armed and constitute a force superior to any band of regular troops. See, it's this whole thing, the people are armed. There's a theme here.
Possess firearms.
And why then are 134, 25, and 27 unconstitutional?
Because in this case,
Because
it
they are
infringes on
infringements.
that individual
Lady.
right. It infringes because it criminalizes the conduct of possessing and carrying a firearm for self-defense purposes. The no exception language by the lower court and in the moving papers is not an exception for permitting purposes. It doesn't provide an exception for any type of carrying. Any carrying, whether it's with ill intent, whether it's for self-defense purposes, is still criminalized conduct. And so when we get to, again, the first prong of Bruin is the conduct covered by the Second Amendment? If the answer is yes, burden shifts to the state to justify, and the language they use is the regulation, be it a statute or rule, justify the regulation through a national historic tradition.
You argue that 134.9 is an element, an attendant circumstance.
Yes.
If the complaint had alleged without a permit, would your argument be the same?
It would, because the language in Bruin focuses on conduct. And we look at the conduct element. Is the conduct element infringing on this individual Second Amendment right? And so other attendant circumstances may be there, and that would go towards the second prong as to whether the regulation as a whole can be justified. But our position is the same. The first prong focuses on conduct.
Were 134, 25, and 27 also amended?
I don't believe so. In trying to square where our state
Don't blame
provision
me, you guys.
and our,
Just find it.
whether it's collective or not, falls into places, we do believe there is a place
You
for that.
click the link.
If the answer to the first part of Bruin is no, then there is this question as to whether the regulation meets rational basis under perhaps the state Supreme Court, the state constitution. But
By the way, under our state constitution, we could provide more protection than the Second Amendment theory. What would that look like?
That, an enhanced protection could get us to very different places. I'll just put it at that. And this court definitely need not go that far. In this
He's
case.
right there. Your state constitution cannot
yes,
be
the Second
more
Amendment does set the
restrictive than
floor.
the federal
Can I
constitution.
go back
But
to
you
Mr.
put
Ross'
more rights
sort
in
of
there.
closing hypothetical of somebody in January of next year
Your state could
wanting to
literally
bring a
pass
firearm
a
into this building
constitutional
and
law,
having
and it
a
would be constitutional to say
deeply
that
held belief
everybody
that
in your
the
state has
revised
to own,
firearm
everybody of
statute
age has to own an
is not
AR-15.
compliant with Bruin, would they be able to simply carry that weapon into this building under your view of our standing requirements?
My response is this, is we're not saying that that conduct described is lawful. We are simply asking that even in that extreme and terrible situation, that that person, once prosecuted, would still have the ability to at least raise the question. That's really the issue of standing. The state is playing up fears of violence, fears of chaos, and its answer today is to create a barrier for defendants and prevent them from even raising the constitutional challenge.
Let me look at
The
something.
answer would be, yeah, but you had to get a permit, which is their answer is, yeah, you can raise it. But the answer is you have to get a permit and you have to read the statute, I guess, in pari materia, these three provisions, and the looking at the whole scheme, getting a permit is part of that scheme. So the answer would be, you have to get a permit, and that's, that's a requirement for standing, I guess.
That's an enhanced view of standing, and that's a very radical and different view of standing that this court has never gone that far. I mean, Armitage is unclear about it. Armitage seems to be grounded in the general rule. And if that is the rule of standing for one particular type of constitutional challenge, it stands alone. And it is far more radical than, anything in Bruin. It goes beyond anything that we've seen before when it comes to the law of standing in Hawaii.
Also, just if you can articulate.
So standing is designed, at least from our cases, to show that it's not meant to be a barrier for people who have a real controversy. That's really what it is. It's a form of justiciability. And to say that we're going to restrict standing, is a step that this court's never taken. They've actually gone the other way and have allowed more enhanced standing for, say, a First Amendment or a religious challenge. But to say a Second Amendment challenge is different, and that we're going to require something that's not in the pleading, that's arguably a separate element entirely, before we even get to this issue of whether you can even raise it in a motion to dismiss, is a much more restrictive approach that's never been done before.
If they'd pled it, in your view, correctly, and as Justice McKenna noted, so that without having obtained a permit as required by 134.9, the defendant did the following things, you still think that's inadequate because you think, if I understand correctly, Bruin is just focused on conduct and not on the attendant circumstances. Can you explain that, Ben?
Yes, the first prong in the Bruin test is whether the conduct is protected. And they spend a lot of time discussing that aspect of it. The plain text of the Second Amendment covers an individual's conduct. When it goes on, it describes if it is, then it's presumptively protected. The government has that burden. And then there's the final line of the Bruin test. Only then can a court conclude that the conduct is outside the Second Amendment's command if the government meets its burden. And so there is this emphasis on conduct because regulations, obviously, criminal laws encompass much more than just conduct element. So the focus is from the Bruin test itself.
To make sure I understand, you did not challenge count 3, is that correct?
Correct.
And count 4 is the trespass, count 3 is the failure to obtain a permit.
Permit to acquire, yes.
Right. So that count is still there.
That's right. This is still a viable case. Even if it is affirmed, it's still going to be heard in the circuit court just without the place to keep counts.
Is there anything in the record that explains why that count wasn't dismissed? And I certainly don't want you to share anything that's confidential.
Well, partly because, again, the conduct that is Mr. Wilson's being prosecuted for in counts 1 and 2 is the carrying of the firearm outdoors. Permit to acquire is a different form of conduct. And again, that would call for an entirely different approach under Bruin to look at what is the conduct of permit to acquire. So the conduct element here was very clear. The words almost are identical to the Second Amendment itself. And so my time,
Anything to wrap? You have a couple minutes if you'd like to
just in some,
summarize your argument.
thank you. The defense recognizes that Bruin has really wreaked a lot of havoc across the country and recognizes that Bruin
After he gets done, the state's
causes all
lawyer
of
gets
us,
to get back up there and do his own
citizens,
problem.
judges, as lawyers, to
And then we'll
rethink
look a little bit at the
the
opinion
Second
in the
Amendment
case,
itself
we'll
and
look at
all of
something
our
out of South
regulations.
Carolina real quick.
The answer, however, is not to say that certain types of people can't even raise the question in court. We believe that Mr. Wilson has standing and that the dismissal should be affirmed because he has standing and because the state has not engaged in the Bruin analysis below.
Remember,
Thank
this is the Hawaii Supreme Court. The lower court shot all the stuff down and said, yeah, his arguments are correct. Yeah, all these permits are, and the thing is, especially for a permit to carry, like I said, this island, Hawaii, had not even issued a single one.
Mr. Ross, to rebuttal.
And
Thank
they
you,
were
Mr. Chief
rarely
Justice.
giving out permits to acquire.
Just briefly on the waiver issue, I don't think the state waived the issue of the circuit court's factual findings. Among other things, the state submitted its own proposed findings of fact, conclusions of law, which the circuit court rejected. So the state made it clear what it thought the proper facts should be. So that issue was preserved. Mr. Lowenthal has said that there's no challenge to 134-9. I say that's fatal to Mr. Wilson's claim, because the only arguable problem with Hawaii's law is that 134-9 is too restrictive in allowing someone to get a carry license. Place to keep simply says you can't carry unless you have a license. And we know from Bruin that's okay. Bruin allows the states to condition carry on obtaining a license. And the state's not asking the court to come up with some radical new restriction on standing. The state's simply asking the court to do what it did in Armitage. In Armitage, the court said, had petitioners attempted to follow the application process, then they would have had standing to challenge the constitutionality of the regulation in that case. The same is true here.
Is it an element? What is your position?
I think it's a defense to, it says, the statute says, except as provided by 134-9. So I think if you want to show that you had a carry license, you can do that.
Well, if it was an element, you would have put it in your complaint, right?
Right. That if the state believed it was an element, it certainly would have been included in the complaint that he was carrying without a proper license to do so. But I think it's a defense that the defendant can always raise if they in fact have a carry license.
The
state's position is the application for a license is absolutely critical because otherwise, first of all,
it shouldn't have to be harmed by it first. All this
by not applying,
shouldn't be arguments about
Mr.
standing.
Wilson deprived the state of the ability to deny him a license on a constitutional basis, on a basis, for example, well, the gun you have was acquired illegally, so we're not going to give you a license to carry it around. Or, you know, maybe he's a felon. Maybe he's got some mental problem in his history that we don't know that because he never applied.
Well, when you call him with the
require anyone who's going to make these sort of challenges,
he was a
felon and yet go and make the application for a license.
He had been adjudicated.
Danger of
that then too.
Place to keep is tied directly to someone carrying without a license because the state doesn't know you're doing this. If the police are going to go, for example, if they have a warrant to go arrest someone, it might be good for the police to know that person has a concealed carry license and is armed. Otherwise, it creates a much more dangerous situation, both for the person being arrested and the police. From the perspective of the state, that's why requiring the application is critical, and it doesn't require any radical reinvention of the standing precedent. It's supported by both Armitage and going back over 50 years to Grahovic. So
you don't think this is an expansion of Grahovic? In other words, we seem to have had a history of expansive interpretations of standing in this context of criminal defendants challenging the statute.
I don't,
Dialing back on that.
I don't think it's an expansion of Grahovic because the key element, the key point of Grahovic is you don't get to challenge anything, any statute but the one you're charged under. Here, there's nothing wrong with the two place to keep statutes saying you can't carry unless you have a license. That's completely acceptable under Bruin. The only challenge they can raise under Bruin that has any
not if your
merit
licensing
whatsoever
schemes were so
is
hard.
the
Nobody
theory
was
that
getting it wrong.
134-9 makes it too hard to get a license. But they've conceded they're not challenging 134-9. So without the challenge to 134-9, all you have is place to keep saying don't carry without a license.
So if he had applied for a license and it was denied and then the scenario played out, would he be able to challenge the circumstances of that denial as part of this case?
I think he would have a better argument, and then the reasons for the denial would become important at that point if he was denied for a
playing a game of
for a theoretically
way.
improper basis under Bruin, then maybe he could raise that issue. But that's a very sort of outlier scenario, which I'm not sure is easy to figure out. But I do think it's a much stronger argument for the defendant if they have applied, but that didn't happen here. So I see my time is up unless there are any other questions.
Anything further for the court at this time?
No, Your Honor. Thank you.
All right. Thank you to both of our counsel today. The court will take this matter under advisement.
E ku iluna, please rise. Ua
Of
ho'o
course,
malolo
the
ia
court
mai
ends up
ne
siding
kea
with the
aha.
state. They basically say that no, you don't have an individual right to keep and bear arms. Let's look through a couple other quotes. And again, this is kind of a short, abbreviated list with a few things on it, but I have been through this list and actually looked these up in the Library of Congress and read all of these. It's a time consuming, but it's not hard. This was very much like the original draft of the Second Amendment. The right of the people to keep and bear arms shall not be infringed, period. A well-regulated militia composed of the body of the people, guess what? The body of the people trained to arms is the best and most natural defense of a free country. That was James Madison. All right. Let's look at another one talking about the ultimate authority wherever the derivative may be found resides in the people alone. Really sounds like they're talking about militia rights here, doesn't it? Let me see. We went through necessity as a plea. A militia properly formed are, in fact, the people themselves. So even if you got to the point where this was just militia, well, the militia is the people, you jackass. So it still covers the fucking people. Those two are not exclusive from one another, no matter how you slice this. And include, according to the past and general usage of the states, all men capable of bearing arms. To preserve liberty, it is essential that the whole body of the people always possess arms and be taught alike, especially when young, how to use them. In what way does that sound like this is just the militia? That only the militia should have these things. Considering we can go look, I use the 1783 Mass Act all the time. They were going out and inspecting private citizens' property to see whether they had powder stored improperly. And it lists the types of weapons and stuff that they were looking for. Cannons, swivel cannons, mortars, bombs, grenades. It lists all that shit. And if the government did come in and tell you that they were taking your property, they first had to put you in front of a jury. The jury had to agree. And then if they took the arms, they sold them right back to the fucking public. People wonder why my blood pressure shoots to the roof dealing with idiots like this who are supposed to know the Constitution. Kurt, what's up, my brother? How you doing today? You just came to jump on and watch me have a stroke, didn't you? Good Lord. Yep, Kurt. I got to look back through Europe and Michigan. I got to look back through their stuff the next little bit, see what else they're doing. I know Georgia's got it, right across the river from me. They're I don't know how far they've gone, but they're pushing safe storage bills, universal background checks, and a few other things. I don't think they've got a huge chance in Georgia, but I don't put anything past these people either. So we'll see. Alabama, they've got a couple people trying to push red flag laws. Trying to push red flag laws, trying to make it illegal for anybody under 18 to have something like an AR, which excludes a lot of kids who shoot and hunt and fucking you can't. Oh, these people. Let's hit this real fast because South Carolina, the other day, the Senate passed. They took the House's bill. The House passed constitutional carry last year. And the Senate decided we're going to amend this. Instead of passing it, we're going to amend it and then send it back to the House. And now it looks like the House basically said, nope, we are not passing the Senate's version. So let's read through this a little bit. The Senate passed Bill 2815, bringing the Palmetto State one step closer to giving residents the right to own and operate a firearm without a permit, while also sending a piece of potential legislation back to the House. If they had just passed the House's version, it would have went right through the Senate, went right to the governor, and been signed. However, they threw some amendments in there that the House didn't like. So the House said, no, we're not passing this version. However, House Majority Leader Davey Hoyt, whatever, however you pronounce his damn name, said he believes the bill in the House's original form is a better reflection of what constituents are seeking. And this was a post from him. While I respect the intentions and efforts of the Senate, the House Republican caucus remains united in our decision to non-concur with the Senate's changes, Hoyt said in a statement on X. We will return a clean version of constitutional carry, Second Amendment Preservation Act, to the Senate next week. So this coming week should be. The exact version that was overwhelmingly passed in the House last year. Our dedication to protecting the Second Amendment rights of law-abiding citizens remains steadfast. It is our firm belief that this bill, in its original form, best reflects the fundamental rights and freedoms of our Constitution. That's where he posted a statement. Constitutional carry, also known as House Bill 3594, was introduced by Representative Bobby Cox. So he introduced the House version. The Senate amended the bill, adding penalties for unregistered firearms owners who break weapon statutes, mandated that citizens report stolen weapons to local police, and offered free weapons training with the hope of encouraging safety. The Senate, bunch of fucking morons, and especially that one Senate leader, the Republican, absolute FUD idiot, should have just took the House bill, told everybody with amendments, we will address those in separate standalone bills. We are passing constitutional carry, period. We can address stuff in standalone bills. It would have been that simple. But Republicans, in and of themselves, are screwing us just like Democrats are. The speech, if you guys saw it, the speech, and we listened to it the first time live and then went back through it and listened to it again. And Night Strike covered it on his channel too. The speech from the so-called Republican leader in the Senate talking about, no police asked for this and we're endangering law enforcement and all this horse shit. Please, for the love of God, man, if you vote, don't vote for these idiots. If they say they're for the Second Amendment, but don't vote for them. Even if they're the better cancer than the Democrats. because all they do is they play these fuck games, and then we're still stuck in the same position, and then they just cede ground even slower to the Democrats. That's all they do. Yeah, they could have, Tread. They really could have. And that was part of my initial thought when I started to read that. But getting to the point, I do think the House bill was better. I mean, if you want some of the shit that the Senate stacked on, like I said, those are standalone bills. Increased penalties for someone committing a crime with a gun, I'm all for that. Pass it in a standalone bill. That's a criminal statute anyway. So pass that in a standalone bill. This whole thing about whether you can carry in these placards and stuff like that, one, those placards shouldn't even exist. Oh yeah, Night Strike's fixing to lose his mind. But see, we went through a lot of that in Alabama before they passed constitutional carry here, and went through a lot of these same arguments. And I watched all of the arguments. I still got to look and see, because I can't remember. I don't think Alabama started putting their stuff on YouTube until after they did all the stuff with constitutional carry. I got to go back and look. I got to find it, because if I can find the video, we'll look at all this bullshit that was said in Alabama before it. But in the Senate really was. A couple people in the Senate were trying to kill the bill. A couple of Republicans. The lead one, I can't remember the guy's name offhand. He's so fucking frustrating. I don't think enough of him to even try to remember his name. But I don't know, man. I got to see. This next week, I got to start checking the schedule in South Carolina to see when they try to put that through committee or introduce it. And at any time, if I can cover it, I'll cover it. But I know Night Strike will cover it any time it comes up too. No, I don't think they hit it this past week. Not that I saw anyway. I'm thinking, was it Monday or Tuesday? They were supposed to cover it, and I think that's when the House just blew over it real fast. I'd have to check one of Night Strike's last stream to remember which day it was on. It may have been Tuesday, when they were gonna vote on it, and then they just ended up blowing past it. And the reason they blew past it is they want to bring up a clean bill again. And if they bring up a clean bill again, like it or not, but if they bring up a clean bill again and it has to go back through the Senate needs to let the bill go. They need to vote on it clean, let it pass, and then if they want to do other shit, vote on clean amendments or standalone bills. That is the way to do that. All right, Gabriel, take it easy, my brother. I ain't got too long. I got to bounce too. So it should be this next week. They should introduce it, and hopefully, they'll vote on it pretty quick. I think they should be able to vote on it pretty quick in the House, and then we'll see when the Senate takes it up. And it'll probably be another dog and pony show in the Senate, judging if last time was any kind of measure of what these guys are like. I'm not. It'll probably have to go back through the committee process again in the Senate. I'm sure they'll slam it through the House pretty fast, but anytime we figure out that it's coming, if we can stream it, either me or if I know about it and I can't be there that day, I'll send it up to Night Strike just to give him a general reminder, because I know he'll probably be covering it too. And we'll see how it goes. This stuff in these courts right now, the Hawaii Supreme Court basically saying that no, that you don't have an individual right to keep and bear arms. That was the Hawaii's Supreme Court's decision. I'm be willing to bet that's already headed up to the district court. And if we can find oral arguments in that, then we're going to play those. what was the bill number? The old bill number in the House was 3594. It's gonna have to be a new bill number, I believe, when they bring it back up. The Senate bill was 2815. Let's see. Let's roll through this real fast. All right. The Senate bill was 2815. The House bill, where is that? 3594 was the House bill. Let's see. What does it say? Following the House's decision to reject the Senate's amendments, Governor Henry McMaster said he was disappointed with the lack of action on the potential law. This decision by Republicans in the South Carolina House to reject Senate changes to 3594 keeps the revolving door of career violent criminals wide open, Masters wrote. For over 2 years, law enforcement and victims of crimes have been begging the General Assembly to pass a bill with stricter increased penalties for illegal gun use and possession. This is how we keep career criminals behind bars. So again, that can all be done with a standalone bill. It doesn't have to be done in the carry bill. Pass the carry bill clean, and while you're passing that carry bill, pass a standalone bill that says if you use a firearm to wrongfully deprive someone else of life, liberty, or property, then you get so many more years or something like that. Take your average penalty if I just knock someone over and rob them, and ramp that shit up if I use a firearm. It really is that simple. So again, that's an easy standalone bill. That is a bill that everybody, Democrat or Republican, should be able to get behind very easily. If you're passing a bill that says there are expanded penalties for using a firearm in the commission of a crime, we'll say this: it shouldn't be just for the crime of carrying a gun. You should have to be doing an illegal act with that firearm, robbing someone, brandishing it at someone, in commission of a crime like robbery or rape or murder or some shit like that. It would be extremely simple to write that. And it would be extremely simple to ask everybody, hey, okay, we're going to separate these things out into two different bills. We're going to pass the carry bill, but we want this bill kind of as a companion bill. We want everybody to just go ahead and say, give their opinion on it and be ready to sign that bill. Be ready to vote yes on it. It'd be extremely simple to do. But I'm telling you, some of these Republicans in the Senate don't like constitutional carry, and they'll do anything they can to sink it. For which I say, if you are a voting member of the public in South Carolina and your Republican senator is the one hanging this shit up, I would definitely give him a call and tell him he's a prick and you're never voting for him again if he, tries to block this bill from coming through again. Yeah, dude. I had South Carolina Senate pulled up in here earlier. Do I still have it up in a tab? South Carolina legislature. Oop. No, that was. Well, hold on. Let's refresh this because I was right on the tab for 3594 already. And let's see what it says. See if this has been updated, and then we'll search it again. That was old text. No, I'm probably going to have to go. Let me see. So that's the text. Built him in. So, yeah, I mean, it just shows it rolling back. So, let's see. What is it list down here at the bottom? Yeah, so it went back to debate on 213. Senate Journal page. That was when they passed. So yeah, it looks like it's coming back up on 213. Yeah, dude, it's always a pain trying to look at your phone, but that's the final entry right there at the bottom line for the bill. So it looks like the House on 213 is going to bring it back up. And they may not change the House bill number. They may just put it right back out as a clean bill, which is what it looks like right here is what they're going to do. So, I mean, really, the House didn't even take a vote on it the other day. They just said, nope, we're not doing it. So that's where it's at now. So we'll keep an eye out on the 13th. Let's see. That'll be next Tuesday. So if anything happens before 12 o'clock, I'll try to be covering it. And if it happens after 12, then Night Strike should be covering on it. Well, Night Strike might cover it on his own channel anyway. And who knows, I might just kind of piggyback off of him. So that's, yeah, this coming week, coming through on the 13th. And that'll be in the House. And I'll try to keep an eye out before then, but it looks like it will be the full House. I mean, it didn't list, at least I don't see, it didn't list it coming back up in any kind of committee, because it normally lists like referred to a committee like it does here, recalled from a committee. And this just says the House and adjourn until 2/13/24. So it looks like it'll come back up in the full House next Tuesday. And we'll get to see it coming back up. So that'll be another interesting day to see what the House says and how quick they can just push it on, because they already voted on that clean bill last year. So more than likely, everybody voted for it last year is going to vote for it this year. They should be able to push it right on. And it'll be the same arguments you heard before from the Democrats about blood in the street, and the same arguments from some of these Republicans about, putting law enforcement in danger. Anybody who's a danger to law enforcement with a firearm is already carrying a firearm, regardless of your fucking permit law. Anybody with any sense knows that. So, it's some of the arguments I had with people that I know about, Alabama's constitutional carry. Well, it gives the police this way to see whether someone is a criminal before they carry a gun. And again, let's do my little skit like I've done quite a few times. I've never heard of a gangster who was going to go out and commit a serious crime with a firearm, who went to walk out his door with his gun and went, "Oh, fuck, I can't do that. I don't have a permit. I've got to leave my gun at home." That's never happened. So, anyway. Well, when the House brings it back, they're going to bring it back without the amendments. They're going to bring it back as a clean bill. with no amendments done. So they're gonna push it back just like the House originally passed it. Then it comes down to the Senate, and whether the Senate and these brainless people and spineless Republicans, whether they will go ahead and pass it as a clean bill. And then, like I said, do some standalone bills. If you want to increase penalties, that's an easy standalone bill that everybody and their grandma will vote for. Even these Republicans who are so against constitutional carry, they will vote for a standalone bill to increase penalties for someone committing an actual crime with a firearm. And it, Democrats, well, hell, they'll vote for it too, more than likely. Now, some of them, I shit you not, some of them will argue that, well, that'll negatively affect mostly minority people. And then they'll want to argue it that way because they're so against carrying guns in the first place, they don't give a shit. So we'll see. Anyway, Perps, I'm going to get out of here, man. I got a few more things I got to run around and try to do today, especially before it gets dark here in a little bit. So anyway, you Perps be cool. I'm about to hit the bricks, and I'll catch you guys on the next one. Definitely, guys, if you see anything you want me to cover, hit me up, and we'll cover it. Don't care what state it's in. If you're up in BFE somewhere and you want me to cover something just to throw the word out, let me know. We'll throw it out there. Other than that, man, you guys be cool. As always, Perps, keep that thing on you at all times. I'm out, man. Love all you guys. Tread, all the rest of you guys, freaking, man, take it easy. You guys are cool as shit, man. Later.